So my name is Richard Case. This is my second video on my series about my court case suing the Ministry of Defence for a Royal Air Force recruitment court, which as far as I'm concerned is factually inaccurate, factually incorrect. Just to give you a bit of background, which there's more detail in my previous video going through the full history. I applied to become an RAF reserve last summer. It's now June 2025. Just to help them out, really, serve my country, you know, help them out a bit. It's like a weekend a month being a reserve. I had the medical assessment. They deemed me unfit for asthma, even though I grew out of my asthma when I was about 16. Affected me very mildly between the ages of about 10 and 16. And this is my second video, just to go into a bit more detail about what happened in the first hearing, which was on the 6th of June. It's now about the 23rd of June, so it's 2 or 3 weeks ago. Yeah, it was the oddest experience. I've never been in court before. This is Worcester County Court, where I'm doing the claim. Never been in court before, although I had actually visited the court just to see what happens, but I'd visited the Crown Court. This is a combined court, so they do criminal in the Crown Court and they do civil in the County Court. It's all in the same building. Just to see what happens, although they're completely different. You know, the civil claim is done in a small office where the judge is basically has her own room. She sort of sits behind a desk that's separated off from the rest of the room behind a wooden barrier, and then there's a desk where with space for probably about 8 people. Yeah, very strange. I turned up, it was on a Friday afternoon, there wasn't really anyone around. The first thing that happened was, because up until that point I'd had no communication whatsoever from any of the parties that I'd sued. On the morning I'd got one of their skeleton arguments, so I knew at least they were going to defend it. It turned out that there were 2 barristers had arrived. One of them tried to approach me in the lobby, and I now know why they approached me in the lobby. It's because they actually hadn't managed to serve me with their document before the hearing. So they tried to do it like 10 minutes before the hearing. I wasn't having any of it. I just told them to go away. I wasn't interested, which actually played in my favour, because it meant in the hearing I could tell them, well, I haven't actually received your documents, so which is unfair. But yeah, so the hearing was very strange. It was only half an hour. Well, it's supposed to be only half an hour. I think it was a bit longer than that. There were 2 barristers, me, 2 barristers defending, one from the Ministry of Defence, one from their contractor that had done the medical assessment, the judge and me. The first strange thing that happened was nobody was introduced. I had no idea who was there. I didn't know who the barristers were, didn't know who the judge was. They didn't introduce me. We knew the judge had told us to sit on particular sides of the table, so we knew who was the claimant and who was the defendant. But the judge knew exactly who the defendants were. She knew their names, she knew who they represented, she knew their arguments intimately. And I'll come back to that in a bit. She hadn't even read my claim. She hadn't. About halfway through the hearing, she asked me what exactly it was I was asking for. So I had to explain I want my medical record amended under the Data Protection Act, Section 46, because and she actually admitted not knowing what the Data Protection Act was about. So I said, well, under Section 46, there's, we have a statutory right to amend inaccurate data held against us. But yeah, but halfway through, I was just in disbelief. Like I had no idea who was sitting in front of me. She had told me all about what they were claiming. Like I said, one of the documents I'd had for about 4 hours. The other document I didn't even have a copy of. So she basically told me what they were trying to defend against. But the main issue was in that hearing was that I'd actually sued the wrong people. So all of my correspondence had been with the Royal Air Force and their contractor. As it turns out, the Royal Air Force are not a legal entity. They're called a legal person. So if you have to sue someone who is a legal person, Royal Air Force aren't, and it's all covered by the Ministry of Defence. So mainly that hearing was about me changing the identity of the defendants on the claim. Now, why it took 2 barristers and a trip from, one of them came from London, one of them came from Birmingham, trip to the court just to say, hey, you need to change the names on that claim form, I have no idea. Well, I do have an idea. I think this is what the UK government and legislature has come to now. This is the way I read it. They're all in the same thing. From what I've gathered from the correspondence so far, they talk to each other. Like those barristers and the government legal department, who is the department who represents any claim against the government, you know, say the Ministry of Defence or any other ministries. It's all covered by the government legal department, and I've sort of had a back and forth with them since the hearing, and they already know things that I've only just sent to the court. So I think they have access to some digital, you know, I've been doing things through, you can do things through email at Worcester County Court, but mainly I've been doing things through paper. There doesn't appear to be any other way, but I think in the background, they have another system that they use where the judges and the government have access to. You know, there is, it's called I can't remember exactly what it's called, but there is a digital system that some courts use, and I think basically everything's been registered on that, because within a couple of days the government legal department know more about the case than I do. So, but basically I think what they essentially do is they try and scare you off. So they send 2 barristers, they've obviously both submitted arguments, they've also both submitted costs. Now I know for a fact that barristers these days cost about, I think it's about £800 an hour, not a day, an hour. So you can imagine 2 barristers, they're probably both going to charge for most of the day, so you're probably talking in excess of 10 grand in costs just for that hearing. They've deferred the costs until the next hearing, but another weird thing that happened in that hearing was the judge was, you know, perfectly friendly with the 2 barristers. She barely spoke to me, and she got one of the barristers to draft a, they call it a draft order, which is basically a court order drafted sort of on behalf of the judge. So that's why it's called a draft order. But it basically lays out what you want to happen in sort of in the sort of terminology that the court would use on the form that a court would use to actually send it out to any of the claimants and defendants. So she got one of the barristers, and he did it right there in the hearing on his laptop to write a draft order ready for her to sort of approve. He took her email address and he emailed it to us all, you know, within an hour or 2 after the hearing. She replied by email and approved it immediately. I guess because we'd all sort of approved it. I mean, in the hearing, she gave me the opportunity to sort of object and sort of like have my say on what should be in the order. But you know, having had no experience and not knowing what was going to happen, and having barely had a chance to read the documents that the barristers had sent me, and not even having a copy of one of them, didn't really know what to say in that hearing. You know, no solicitor present, so I just had to sort of basically state my case. You know, say, look, I haven't had these documents. don't really know what's happening, but you know, I have no option to agree with it. Afterwards, I did a lot of research over the weekend, and I managed to come up with a pretty good argument against it. So this is what I've argued. First of all, the two barristers represented non-parties. So if you look up the civil procedure rules, the people in the hearing obviously have to be parties to the claim. It sounds obvious, something I sort of hadn't really appreciated in the hearing, because so like I said, I'd sued the Royal Air Force and their contractor, who actually was the two barristers were representing the Ministry of Defence, and the other barrister represented, and this is where it gets a bit weird, I'd sued one company. The contractor is actually split up into several different companies, and the company I'd put on the claim form was different to the company that the barrister was representing. So technically they're not a party either. And when they're not a party, A, they're not supposed to be in the hearing, and they're definitely not supposed to be able to submit documents, you know, submit arguments and submit costs. So that 10 grand that I suspect that hearing was supposed to cost, you know, the judge accepted their submissions of costs, should not have happened. So they're the two things. So I've asked for their submissions to be struck out, which basically means, you know, thrown out, taken off the claim. I've asked their costs to be thrown out. Now, they may argue that even though the Ministry of Defence is not a named party, under the Crown Prosecution Act 1947, I think it is, Ministry of Defence can act on behalf of, you know, the Royal Air Force, the Army, the Navy, all that kind of stuff. So I may not be able to get that struck off, we'll see. But technically they're not a named party. What else did I ask? I asked for the order that was made to be struck out. So, and all this is called an application to the court. It's done under form N244, N for November 244, which you actually have to pay for. I'll actually go through more of the process of how the court process works in another video. You know, explaining how the forms work and the payment and all that kind of stuff. Yeah, so it's an application for an order. What else did I apply for? So I've applied for what I actually made another mistake on the claim, which was I applied for an application for an injunction. So under the claim, I'm trying to get an injunction for them to amend my medical record. So an injunction either forces someone to do something or prevents them from doing something. There's two different sorts of injunction. But what I'd actually asked for was not just a claim under the Part 8 of the Civil Procedure Rules, but I'd actually asked for an injunction. I'd applied for an injunction. Now it turns out when you apply for an injunction, it's just an interim injunction, which might be the reason they processed my claim quicker than normal, was because I think an interim injunction gets processed faster because it's for things like, you know, preventing people from, you know, harassing people and all that kind of thing. So the one thing I did agree to in the hearing was to agree that I didn't need an interim injunction. You know, I'm after a permanent injunction for them to amend my record, not just an interim injunction, which is just temporary. And you know, so I'm basically trying to ask for two things in two different ways. well, the same thing in two different ways. So I've asked for that to be struck out. I've asked for 45-day adjournment because another thing that they had claimed is that I hadn't gone through the proper pre-action protocol. Just briefly, for all claims, you're supposed to issue a pre-action letter and make sure that you've done everything you can to resolve the situation before you take it to court. They claimed I hadn't done that, basically because the Royal Air Force had told me they'd accepted my pre-action letter, but then they'd sort of sent it to the wrong department and it had been binned essentially. The Ministry of Defence had claimed I hadn't done it. I've got proof that I have done it, but I thought I should give them another statutory 30 calendar month to respond to the pre-action letter. So I reissued once I knew who to talk to. I've now got an email address for the government legal department. And I now know the address of the data protection officer for the Ministry of Defence. I've reissued the letter before action, and now I'm giving them another calendar month to respond appropriately to my pre-action letter. Hopefully we can resolve this out of court, and I can just cancel the court case. But we'll see what happens. Other things that were on the application notes, the application to the court, were to change obviously the names of the defendants from the Royal Air Force to the Ministry of Defence. Also change, and I sort of after the hearing, I sort of re-looked into the Data Protection Act. Again, I can go into a little bit more detail, but basically you only need to, the person responsible for a data protection claim is called the data controller. And it's a bit convoluted because there are, under the Data Protection Act, there are two sort of roles. There are data controllers and data processors. Both need to be registered with the data, with the Information Commissioner's Office. But it's actually only the data controller who is responsible for the data. So in this circumstance, the Ministry of Defence is the data controller. As far as I'm aware, and I do actually have evidence, their contractor did send me an email telling me that the Royal Air Force is the data controller in this instance. So I have that evidence to use in court if necessary. And I've read the information on the Information Commissioner's Office website, which also explains what the difference is between the two roles. And because the Royal Air Force instructed the contractor to perform the medical assessment, it still makes the Ministry of Defence responsible as data controller for that data. So essentially, if the court rules in my favour, I will need to, it's them that is responsible for informing the contractor to amend the data. Even though they probably don't even have a copy, who knows what happens behind the scenes with the paperwork. So I've asked, there was actually 3 defendants on the claim, so I've asked for 2 of them to be removed, the contractor and the doctor themselves, so it should just be the Ministry of Defence. What else have I asked for? So the other interesting thing I've asked for, which you saw I'll put a clip of the front office staff, Her Majesty's HMCTS Court and Tribunal Service staff on the front, the security guards essentially. They've been very helpful, because after that hearing went like that, I was very suspicious, because the judge knew exactly what was, she knew the names of the barristers, she knew exactly what they were arguing, even though I'd never spoken to the judge, I'd never had any communications with the judge, she'd not read my claim. it seemed very fishy to me. So I actually went on the Monday, and I thought about it over the weekend and thought, well, they must have met. I'm alleging, and I realise I have to be a bit careful, that the two barristers that they'd sent, I think must have met with the judge, because she knew who they were, she knew who they were representing, she knew their arguments. So I asked the security staff for a copy of CCTV footage to try and prove that there was a meeting before I arrived. I know they were in the lobby before I arrived. I only arrived about half an hour before the hearing. So it could have happened. I questioned the lady that was the usher. So they have a court usher who sort of acts as a bit like a receptionist who shows you into the courtroom and phones the judge and all that kind of thing. I asked her, a few questions. I didn't really want to go into too much depth, but whether she had records of when the barristers had arrived and how I request copies of the CCTV footage for the lobby and what would happen and all that kind of thing. Just trying to get a bit of a feeling for how, what the hell was going on. As it turns out, what I had to do was email the court in exactly the way as you would with when you send in evidence. So I just requested footage from the lobby and the entrance for that day to try and I just asked for it generically to start with, and then they asked why I needed it. And so I told them what my suspicions were. I didn't really know how much detail to go into, but I said it relates to this court case, and here are my suspicions. And the security staff have just confirmed that they've had the request through now from, it got passed to a different department within the court, and it sounds like the security staff has now been, actually formally requested. So that, we'll see what happens. The security staff have said that it would be redacted, because it's technically a public place, and they explain that you can't just have videos of people, milling around in a public place. So I don't actually know what I'll get. It probably won't be very useful, I can't imagine, but we'll see what happens. But yeah, because of my suspicions, I've essentially claimed under the civil procedure rules that it's just unfair. What you'll find is, I think it is section 1 of the civil procedure rules goes through essentially what the judge is there to do. And again, I'll go into this in more detail in another video. What the judge seems to be there to do is just ensure fairness. They don't need to know the law. They don't need to know really anything about your claim. But they are there to just sit there, listen to what both sides have to say, and make a judgment. But they do have to make sure that certain rules are adhered to, which are I think they're called practice directions and the civil procedure rules. And as part of the civil procedure rules, one of the very first ones, I think it's section 1, is, they're there to ensure fairness. And that hearing did not seem fair to me at all. It was crazy. So I've actually asked the judge, they call it recusal, where the judge basically says, yep, I don't want to be part of this claim anymore, and passes it on to another judge. Now, whether that judge is in the same court or a different county court, I have no idea, but that's what I've asked for. So we will see. It all seems very complicated to me, considering what seemed to be a simple thing. I clearly don't have asthma. I haven't had asthma for a long time. They seem to think they know my medical history better than I do and better than my GP knows. And I thought it would be a very simple thing. But as we're finding out in Britain, nothing is simple anymore. You post on X, and you get a and you get a sentence for 3 years in prison. Okay, you know, just to give you my opinion on the Lucy Connolly case. Not that, you know, I don't know anything about it. I think if you ever find yourself in that situation and the police and the lawyer that they assign to you is essentially coercing you in a very nice way, I'm sure they do it very nicely, coercing you into pleading guilty for something you haven't done. Lucy Connolly did not incite violence. She stated her opinion. In my opinion, you know, I can't remember exactly the phrase she said, but you know, it was, oh, that was it. For all I care, burn their house down, or whatever she said. For all I care. That's her opinion. You know, that's not an instruction. That's not incitement. It's nonsense. But you know, she pleaded guilty to a category, I don't know, a 1A. I don't actually know what the charge was in the end, but she pleaded guilty to a category 1A, and she got the sentence to fit. You know, so that's a lesson to all of us. Know what you're pleading guilty to, and if you don't think you've done anything wrong, plead innocent. You know. So we will see. I'll wrap this up here. It's been Christ. Yeah, it's been going quite a while now. So I'll wrap this up, and I'll continue on with my next video. All right, like and subscribe if you want to hear more of this saga.